The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone. We're just here to give a presentation on novations and contract transfers. As you can see, my name is Alba. I'm a partner here at PilieroMazza in the Government Contracts Group, and I'm here with Kimi Murakami.
Hi, thank you very much for joining us today. I'm Kimi Murakami, and I'm a member of our Business and Corporate Group.
All right, so brief overview of what we're going to be talking about today. We're going to go through a few things here. First, we're going to start out with some of the basics about what is a novation, how exactly do you put a novation package together, what are the key elements, and how do you really communicate properly with the contracting officer or those who are receiving the documents in order to kind of push things through the process as quickly as possible, although as you'll see, it takes a lot of time sometimes to get these things through. And then towards the end, we're going to go through some tips and things that we've learned along the way through our practice, both from the government contracts perspective and from the pure M&A corporate perspective, because there are kind of tricks of the trades and things like that that are important to know, or things that we've learned as we've talked with a number of agencies about novations that everyone should know and should be aware of before you even start this process many times. So let's get started. So first of all, just so everyone's on the same page, what is really a novation? Well, generally speaking, under the Anti-Assignment Act and the Assignment of Claims Act, you can't transfer federal contracts, whether for money or just for free, to anyone who hasn't actually won the contract on their own. General policy the federal government has, I think it's in the best interest of the government and the public fisc that the companies that are initially performing these awards or won these contracts perform them to their entirety throughout the life. And that there's a lot of reasons for that. One of the major ones is cost control and understanding that the government reviewed the work and the proposal of a specific contractor. They have faith that that contractor can perform based upon their evaluation of their proposal, and so they really want that contractor to perform through the end of the contract. But in certain instances, what they call novation, they'll allow the contract to be transferred or novated from one contractor to another. And this is really the only exception to the contract transfer rule, because you most certainly cannot buy and sell federal contracts. So in and of themselves, and we'll get into more specifics later, but that's sort of the general overview. So in order to do a novation, you have to put together a novation package, which has a number of documents in it that all have to be prepared, including whatever the purchase agreements are, a letter from counsel attesting to the fact that everything was done appropriately, and things of that nature. But it's important to understand who you're submitting this to, because when you put these documents together, you need to make sure that you're putting them together for a specific audience. Some contracting officers are more of a stickler, others are a little bit more relaxed, and it's best to know who you're speaking with and to get to know your contracting officers a little bit. And specifically, if you have an administrative contracting officer. So if you have a number of contracts, or if you have a number of schedules, for instance, and you're trying to novate contracts from one company to another, in that circumstance, you might have what they call an administrative contracting officer. And those individuals sort of sit atop a bunch of your contracting officers, and they're in charge of the administration of your contracts portfolio. If you have one of those individuals, that person is the individual to whom you submit the novation paperwork. If you do not have an administrative contracting officer, then the contracting officer either responsible for the contract, if it's a single contract, or the contracting officer who is responsible for the largest unsettled balance, the unpaid bills that you've already submitted. Whichever contracting officer has that for each agency, that is the person who you're supposed to submit the documents to. So if you have 3 contracts with state and 3 contracts with DHS, let's say, you're supposed to look at the contracting officer responsible for whichever one of the 3 at state and whichever one of the 3 at DHS has the largest unpaid balance, and that's the individual who should be responsible for reviewing and to whom you submit this paperwork. So that's just important to note. So then you can target your focus to that individual. The months or so leading up to a novation, you should really try to speak to that person and also try to feel them out onto how they feel about novations, because as we'll touch on later, a lot of the novation issues are discretionary, so the government doesn't have to allow the novation. And there's really no time period in which they have to do it either. So it's something that if you speak to them early, get them acclimated to the process, it can really streamline things and make it a lot easier. So it is important to know the individual to whom you are submitting. When do you submit the novation documents? Well, there are things that sort of rotate or revolve around the novation itself, like if it's an 8A contract, certain waivers and other things, and that's not exactly what we're going to get into today. But the actual novation documents themselves, those have to be submitted after the sale or after the purchase has occurred, where a contract is implicated. So if you are doing an acquisition of an entire contract, so I mean, entire company, like a stock sale, then after the stock sale is completed, that's whenever these novation packages for all of the contracts to either the administrative contracting officer or the contracting officer with the highest unpaid balance for each agency, that's when you submit that documentation. So leading up to your purchase, if it looks like things are progressing nicely and that there is going to be some sort of purchase, then at that point, that's whenever you have to submit the contracting documents, and it's good to get out ahead of that by speaking with that person once you really think things are going to go through. And then we kind of touched on this before, but because things are really at the agency's discretion, and it's the real statement is it has to be in the government's interest, a lot of the cover letters and some of the statements of the new company and whether they're able to provide the work, which is another document you have to submit, when you're preparing those, they should be really explaining to the government not why you want the contract or how you're going to benefit or anything about the purchase and sale or the acquisition. They don't care about any of that. The documentation, especially in the cover letter, has to be focused on why this is good for the government. And there are certain things that the government likes to key in on that they appreciate more than other things. If it's going to a somewhat larger company, if it's going to like an ANC or something like that, where there's a lot of resources there to help things push through the process, and so the government can get comfortable with that new contractor and make sure that they're not going to get stuck with someone who can't perform or something like that. So really touting up the resources of the buyer and explaining why it's in the government's best interest to make this transfer, that cannot be undersold. That is the most important aspect of these things, especially with contracting officers being very wary of making sure all the T's are crossed and the I's are dotted. If you can tell a good story, it'll really help push the process through. Okay. And I just want to note real quick, I know there's questions and things like that coming in, so we'll try to get to those things towards the end, and if we don't get to them, we'll obviously answer them afterwards through like personal emails from either Kimi or myself. But so just going through some of this stuff. So how long does novation normally take? And that's somewhat of a tough thing to call. It depends on the contracting officer and their workload, and it also depends on whether the agency has some preconceived notion against or for the novation of a specific contract. And I can tell you, if you look at something like, let's say, the STARS 2 contract, a lot of agencies have no problem novating contracts, but with STARS 2, there is this feeling within the agency, within GSA, that there's too many STARS 2 contract holders already. And so because there's too many already, they're more inclined to let them sort of, quote unquote, die on the vine instead of novating them over. And that's been a particular hurdle that we've had to deal with And so if you are doing a pure asset sale of something like a STARS 2, it's important to know that and to get out in front of it as much as possible, speaking to the contracting officers, trying to get them comfortable, because at that point where the novation is sitting on their desk, if their boss or some of the higher-ups are telling them, we don't want to really approve these things, they'll just sit on it indefinitely or deny the novation and make up some reason. And it's very unusual that these things actually get litigated, or you can try to force an agency through a novation process. And so I would say, to directly answer the question, you should be willing to have anywhere from a month to 6 months. So if you split the baby, probably a 3-month time frame is something that would be reasonable there to expect in any time you're doing a novation, and it could be longer depending on how much lead time you give the CO and really push them on things.
Keeping that in mind, because there could be a period of time between the actual sale or transfer of the contract and when the novation will actually be approved, there are certain provisions that we would also recommend you have in your purchase agreement or transfer document, and we're going to touch upon those a little bit more towards the end of the webinar. So what do you submit? So I was touching a little bit upon that, about some of the documents you need to submit to the CO or ACO. All of the documents that need to be in your novation package are very explicitly stated in the FAR. There are about 12 documents or a dozen documents that need to be included in your package, and I'm going to go through each of those right now. So one of the first things that you need to include is an explanation of the transaction itself. This we would recommend that you include in a cover letter to the CO that'll go on the top of your package. It'll include an explanation of the transaction. It'll have a list of all the documents that are included. It should go on the letterhead of the transferor.
Weird. Hold on 1 second. Let's see if we can move. I know a lot of people are saying there's some weird feedback. Let's try to move this around a little bit.
Okay, the next document is the novation agreement. This is a 3-party document between the transferor, transferee, and the government. When you submit this document, the transferor, transferee will have executed the document. Of course, the government hasn't yet. That's what you're hoping for by going through all of this. The third document to be submitted will be your list of the contracts that are going to be transferred. This should include the contract number, the type of contract, the dollar value, and the approximate remaining unpaid balance on the contract. Next is a statement of the transferee's capability to perform. This is something that the transferee will provide, describing all of its resources and why it would be able to perform the contract that's being transferred. Next is the document that affected the transfer of the assets. This is going to be the purchase agreement or the bill of sale. Often we include both. Whatever document was executed to show that there was a proper transfer of the contracts. So that's why, as we were explaining before, the novation package is going to be submitted after the closing for the transfer of the contract. Next is your corporate authorizing resolutions of the board and the shareholders of both the transferor company and the transferee. Again, knowing that this is going to be coming down the road, when you do your corporate authorizing resolutions for the sale and purchase, just make sure to include the authorization for execution of any post-closing documents, such as these novation documents that will need to be executed. Also, you need to have an opinion of legal counsel. This is of both the transferor and one for the transferee. Again, these can be very similar opinions, but as I described, this is going to be an opinion where legal counsel will opine to the fact that the transfer has been properly effectuated. Next, you will need to include the balance sheets of the transferor and the transferee immediately before and after the transfer of the assets. The FAR requires that these are audited by an independent accountant. Generally, we have found for our clients, some of whom are smaller and cannot bear the expense of having to have these audited by independent accountants. Again, as I mentioned, you're talking to the CEO. It's prudent to be speaking to them about the novation package that's coming. And often in those discussions, we suggest that you talk to them about whether or not having actual audited balance sheets are going to make this very prohibitive. And generally, they will agree that they do not have to be audited by independent accountants. Next, if applicable, you need to have evidence that the security clearance requirements have been met. And also you need any consent of sureties if that applies to your transaction and your contracts.
Go back really quickly. Yeah, and another thing, just to go through the balance sheet issue, this is something where we've definitely seen it become an issue, especially where there's a company that has a number of contracts, let's say, but that they're not doing so well, and maybe they're IDIQ contracts that are essentially empty. In those sorts of circumstances, whenever you see, the agency will look at the balance sheet, they'll see balance sheet from the seller sort of unchanging. It might be sort of 0 to 0 or something to that effect. And that's something where agencies, we've seen, or counsel at the agencies, key in on as a red flag. And so if it's a case where you're buying some assets, which would include a contract, from a sorry, someone's saying we can't hear, so just let us know if there's something with the microphone. If you're doing a transaction with a company that is going out of business or somehow very small, and they have some empty vehicles or something to that effect, you're going to have to go through the process and really make it, clearer, more so than usual, that you're not transferring just empty contract vehicles. You're not just transferring a federal contract, buying and selling a federal contract, that what you're doing is really transferring legitimate assets and explaining what those assets are in a way that can make sense and jive with the fact that your balance sheet isn't showing a transfer of assets. And that's something that can be difficult. And at the very outset, when you're planning these sorts of deals, if you're purchasing a company or you're selling your company and you know that you have some of these contracts that are basically empty shells, that is something that you're really going to have to work on and talk about, and maybe really think through what assets you have, what tangibles, intangibles, what sort of value can you put on things and put it in a balance sheet if possible with some of your accountants or other sort of tricks of the trade, so to speak, to put something in there so it shows legitimately that there is a transfer and that transfer has value. So that's just something to pay attention to.
Okay, so when do you have to go through all this and submit a novation package? Under the FAR, asset sales require novation. According to the FAR, novation procedures apply when the third party's interest in the contracts arise out of the transfer of all of the contractor's assets or the entire portion of the assets involved in performing the contract. This is very important. Again, thinking about the policy behind the whole novation process is that you make sure that you are not just transferring the government contracts. It's very, very important in the purchase agreement to be clear that you're transferring all of the assets that are necessary for performance of the contract, as I was just touching upon, such as any employees that might need to be transferred, any intellectual property such as licenses. So it can't just specify that you're transferring one particular contract. You must make sure that you're transferring all of the assets. So novation is required when you have an asset sale, but transfers when novation may not be required may be when you have a stock sale. According to the FAR, a novation agreement is unnecessary when there's a change in the ownership of a contractor as a result of a stock purchase. So sometimes when we're advising clients, if it's possible, it would work that you want to buy all of a company, 100% of the ownership, and included in taking over that company will be the contracts that in those kinds of transactions, generally a novation would not be required. Another time when we've seen or advised clients that you may not need to go through the full novation process is when you have a corporate reorganization. In those cases, there's something that's known as the by operation of law exception. This exception is not explicitly stated in the FAR, but it's very well established by case law. In traditional mergers, for example, when you have a parent company merging into the subsidiary or vice versa, we feel that these are corporate reorganizations that fall within the by operation of law exception, and therefore a full-blown novation is not going to be required. Again, as Sai was talking about earlier, we think it's very prudent to speak with your contracting officer if you think that you're going to have a corporate reorganization that might fall within the by operation of law exception, because it's important to explain to a contracting officer who might be very, very familiar with corporate law and, of course, is very familiar with government contracts law. They may not be so familiar with the by operation of law exception. So it's important when talking to them, if you think you're going to have a corporate reorganization that could fall within this exception, to go in early, explain that it's a corporate reorganization. It's all happening, for example, within a corporate entity, that you have a subsidiary that's going to take full responsibility for the contract, and you're simply requesting that the contract holder will be changed from the parent contracting party to the new wholly owned subsidiary, for example. You can explain that all the assets associated with performing the contract are going to be transferred, so there won't be really any change in the day-to-day performance or operation of the contract. Having these conversations, we find, with contracting officers, they're much more acceptable of agreeing to the transfer of the contract falling in the by operation of law exception. In those cases, when a contracting officer would agree that the transfer of the contract falls within that by operation of law exception, that doesn't mean you're completely off the hook. What we also recommend in those cases is, instead of a full novation, we recommend a change of name procedure. The change of name procedure is set forth also in the FAR at the same place where the novation provisions are. But what's required for a change of name is fewer documents. It's less complicated, and it also takes less time. In this respect, we therefore feel that if you can fall within the by operation of law exception and take advantage of a change of name procedure instead of a novation process, it is advantageous and could make the process go much faster. A change of name agreement is a two-party agreement. This is between the transferor and the government. You would also need to submit a list of all contracts to be transferred, which includes the contract number, the type, and the name and address of the contracting office, and also the opinion of legal counsel for the contractor. Again, in contrast to the novation procedure, it does not require two opinions. So as I was mentioning, the change of name is different from novation in that there are fewer documents to be submitted. It can take a little bit less time, and it's less complicated. So now we're going to talk a little bit about specific types of contracts and different nuances that can arise depending on the kinds of contracts that are being transferred. If you're novating a contract that's and you're a small business, in those cases, recertification is going to be required.
All right. So, yeah, this is one of those issues where, from a small business perspective, it's certainly different from any other perspective. And so, when you're talking about novating a contract to a small business, or even if you're just doing a stock sale where novations are not required, under the small business rules, you're going to have to recertify your size status within 30 days. So after one of these transactions has taken place, that's when the clock starts. Count 30 days, including weekends and holidays, except the last day. If it falls on a weekend or holiday, you go to the next business day. But within that 30-day period, you have to let the contracting officer know whether or not you're still small, given the acquisition or this novation that took place. And if no novation was required, you just say, well, based on the acquisition, here's where it is. And also, it's important to note under the rule, which this is a change that occurred recently, under the SBA rules, both the party who is novating the contract, or actually if it's an acquisition without a novation, both the party that's being acquired and the party doing the acquiring have to recertify on their contracts. So what that means is if you're a company and you are acquiring another firm, right, you're acquiring all or substantially all the assets or you're the stock of another company, when you do that acquisition, you have to recertify on all the contracts that you hold, even if you have, let's say you have 10 other contracts that have nothing to do with this acquisition. You're just buying a company that's very small. You still have to recertify on all the contracts you currently hold. And so that can be an important thing to consider when you're looking at acquisitions generally. And in the novation context, it's a little bit different because when you're doing a novation, you're purchasing a specific set of assets that might not be all or substantially all, and the requirements are a little less stringent. But given that a lot of people try to avoid novations with stock sales, it's important to note that if you do a stock sale, there are other ramifications like that recertification requirement. What's interesting, though, is these recertification requirements by the regulations, and I think this might have been a mistake in drafting, but by the regulations, it's only required if there's an acquisition or a merger from one concern to another concern, right? And a concern is defined under the regulations as essentially a business. So if there's a single individual who is purchasing another company, then the recertification requirement doesn't come into play. And while that's sort of tangential to the novation issue, it is something that's important to note because that should go into your planning process and deciding whether or not you want to avoid novation entirely by doing a stock sale, or maybe novation, while it's sort of a pain sometimes, it might be the better route to go so you can avoid having to do these carte blanche recertifications, especially given the fact that if one concern is buying another concern, there really is complete recertification on everything that they have. And if you really still want to go that route, look into whether or not an individual could do the purchase instead of the company. And there are obviously pluses and minuses and other considerations to think about if you go that route, but it's still something to keep in mind. All right. This slide and the next one kind of dovetail together, but these are some specific issues that people should think about when they're federal contractors, and whether it's they're novating a contract, they're going to buy some assets and have it novated to them, or whether they're the ones who are trying to sell contracts, because eventually you're going to want that novation to go through. You're never going to get paid in most deal structures. So it's important to think about, okay, if you have an IDIQ contract, are there any active task orders on that contract? What vehicles are there that I'm actually trying to transfer? Because like I said earlier, when you're talking about a STARS 2 vehicle, that's something where there's sort of an unspoken rule that there's too many of them out there, and agencies are really trying to scale some of that back. Same thing kind of applies to a MOBIS. It's been not as bad as a STARS 2, but a couple years ago there was definitely an issue with MOBIS, and agencies were trying to step back from having so many MOBIS contract holders. So that was another one of those contract types that might have been a risky proposition to try to novate. And then, are you trying to novate to or from a joint venture? And that really matters in a GSA schedule context. And so, why is that? Well, here's some of the unwritten rules. There we go. Unwritten rules from agencies and why those questions we just went over are important. Some agencies, GSA included, and some people within SBA right now have a view that IDIQ vehicles that don't have any current work in them are not assets. And I've run into this a couple times where we've been transferring real assets, employees, equipment, everything else, and at some point in the process, behind the scenes, without really even telling us exactly what their issue is, someone at GSA with some support at SBA said that they don't consider the contract itself without any task orders to be an asset. And so you can go ahead, what they told us is you can go ahead and transfer all these other assets, that's fine, but you can't transfer the contract because it's not an asset. And frankly, that's crazy. It's most certainly an asset. It has value. And simply because there are no task orders in it is really irrelevant, especially as they've already, in this case, they already conceded that we weren't just transferring a single contract. We weren't buying and selling a government contract. This was a transfer of a number of assets, which just happened to include a contract, which is the textbook appropriate novation. And to come to allege that this textbook example is not an asset because there are no current receivables flowing through the vehicle is ridiculous. And unfortunately, that's one of those cases where there's a lot of agency discretion here. And the question to the client is, all right, well, do you want to go up the chain and to try to get other people involved here to try to push this thing through? Or do you forget it? Or do you try to litigate something? And frankly, because there's so much discretion with these things, it makes a lot more sense to work the political process, and I'm not necessarily the Hill, but I mean political process with the agency and with connections within the agency, and try to push things through that way, because if they're taking that hardline stance and the level of discretion they have, it would be tough. But even if you were to win a case, how much time, effort, money does that take? So it's just one of those things where it's crazy. Like I think it's kind of ridiculous opinion, but it's something that I've seen occur. So it's just something to think about if you're transferring IDIQ vehicles that are currently empty. Another thing to think about if you're talking about the transfer of a GSA schedule, as everybody probably knows who has a schedule, as part of the process to get on the schedule, you have to show that you have 2 years of experience. And the same thing goes for contract novations. GSA generally wants to see the companies that are accepting a GSA schedule contract, that those people have 2 years of experience. So when you're talking about a joint venture, if they don't have the 2 years of experience, if it's a new joint venture, we went back and forth with GSA recently fighting about whether or not they should take into account the experience and performance of the member companies within the joint venture. And GSA is certainly of the opinion that that does not count, that the joint venture itself has to actually have the experience. And so whether it's getting a joint venture on the schedule or novating to a joint venture, that's very difficult to do. So make sure that you have the 2 years of experience in any company that you're trying to novate a schedule to. That's just something where it is a little ridiculous, again, just like the asset issue, but it's something to keep in mind. Next, when you're thinking about or you're listing through what assets you're transferring, that is the number one piece where people get stuck. A lot of companies will want to buy vehicles or assets where a vehicle is included for as little as possible, which makes perfect sense, right? But when you do that, a lot of companies try to target for transfer vehicles held by companies that are either going out of business or they just don't have any work on it, and the owner might be retiring soon. They just want to dump whatever they can. So companies try to do an asset sale with those types of companies, and the transfer is literally just the contract. There's nothing else there. And that's where you gotta think about, really think hard, well, what can you transfer? You know, is there office equipment? Are there any sort of leases that are there? Are there any employees at all that are being transferred? Intangible assets, such as licenses that I think Kimi mentioned earlier, or goodwill, other things like that. Whatever you can put together to show that there are real assets here being transferred, not just a federal contract, is incredibly important, especially where agencies are becoming more aware of the asset issue. It's not across the board, but it's just something to keep in mind, because I know I've seen novations occur where the transfer was literally a $100 deal. And in that case, the contracting officer signed off on it, the novation happened, no problem. But I would say that's more the exception than the rule. And more of the rule is that, especially when it gets to legal counsel within the agency, they're going to look at this and say, wait a minute, under the Anti-Assignment Act, you can't just transfer a federal contract, and you certainly can't buy and sell a federal contract. So what's really happening here? What are the assets these guys are buying to make sure this is a legitimate and lawful transfer? And even with some intangible assets or cheaper equipment, like I have here, computers and office furniture, there was a case we dealt with where the agency kind of saw through that, for lack of a better term, and they said, well, you know, what are these things actually? I want them listed. You've said you've gotten 3 computers and some office furniture and things like that, but you know, it doesn't seem to us like that's something that's really legitimate. It's all been tacked on. And so you know, I used to think, or sometimes I would go through and try to think with clients about what sort of tangible assets they're transferring. And now I'm really telling people in the past few years, like, look, if you're going to do a transfer like this and you just don't really have a lot there, we got to think really hard before we put this in about what we're transferring. And this is something also that dovetails in to what we said earlier about getting out in front of the COs early and often to explain to them what's going on and get them comfortable with the idea, because there is so much agency discretion there, so they can approve these things without this kind of high level of scrutiny if they want to. And it can really help before you go through all the expense of putting documents together, submitting a package and all that, if you have some idea of where the CO stands, so that everybody involved knows to what level they're going to have to explain things in the documents to have any hope of getting this stuff through. So that's just something that is certainly cropped up, and it's important for people to just be aware of these things.
Okay, so as we touched upon earlier, you don't know how long this is going to take. So you've closed on your transaction, you've purchased these contracts, and you put all these documents together, submit your novation package to your CO, and you don't know how long it's going to take. So it's very important that you had provisions in your closing documents, in your transfer agreement, in your purchase agreement that cover you for that transition period. We recommend to our clients things such as having an agreement that you will, post-closing, subcontract the work, so that the transferor will subcontract the work to the transferee who will perform during that period after you've sold the contract or transferred the contract. Another provision we advise that you include is to make sure you think about how long can you tolerate, how long can this go on that it will take for the novation to take place, or will it take place? So you should consider whether or not to have termination procedures or termination provisions in your agreements so that you can unwind or rescind the documents, unwind the transaction in case the novation doesn't occur upon a date certain, or if only a portion of the contracts, if you have many contracts, so if some will be novated but not all of them. So these are some of the kinds of provisions that you need to really think carefully about, knowing that there's going to be a period of time between closing and actually getting the novation approval.
post-closing covenants? Just explain that.
Right, so someone's asking what are post-closing covenants. So just like I was explaining before, for example, agreeing that you will have further assurances that you'll cooperate with each other to make sure that you can work together to get the novation, that after the sale, the transferor is just not going to be there to help you get these contracts novated, that the transferor agrees to novate, novate, that they will subcontract the work so that the transferee can perform during that time.
And from a small business perspective, that like sort of best practice about subcontracting the work down to the purchaser doesn't quite work the same way, because there could be a performance of work requirement problem there. If you are, if a large business, let's say, is buying some assets from a small business, the small business can't subcontract all the work down while the novation process is running its course. What's interesting, though, is since the 2013 National Defense Authorization Act was passed in January 2013, there was a provision in there about, quote-unquote, similarly situated entities, and how the work performed by a similarly situated entity counts as work by the prime contractor, even if that similarly situated entity is a sub, for performance of work purposes. And what that means is if you have an 8A contract, any of your 8A subs should count as performance of work by the prime, or if it's a small business contract, any small business subs. And so in that context, if you have a small business contract and the purchaser is a small business, you actually could subcontract, in theory, 100% of that work down to that other company and still comply with the performance of work, reading the plain language of the 2013 NDAA. Now, there's no regs on that yet, so we're not sure exactly how SBA is going to view that, but it does give you some flexibility there in your subcontracting after a novation has taken place. And the similarly situated rule doesn't just apply to novations; it applies across the board. But like I said, there are no regs on that, so that's just sort of an issue to keep in mind.
The second issue to keep in mind with respect to M&A issues is the transfer of all the assets, and I think we've talked a lot about that, that you're not just transferring the government contract, but also including any of the assets that are necessary for performance of the contract, such as employees, IP, equipment, maybe any capital, so to make sure that you include all that in your purchase agreement. The third issue that we've seen come up and really requires some explanation, because it's a little startling, but in the novation agreement, as I described earlier, this is a three-party agreement between the transferor, the transferee, and the government. In this agreement, the government is going to be able to look to the transferor and to the transferee for the entire period of performance, even after the contract has been transferred. So what this means is that even after the contract's been transferred, the transferor is no longer performing the contract, but the government can look to them, and the transferor is still responsible for that entire period of performance. The same goes for the transferee. The government can look to the transferee for the period prior to the transfer of the contract. And so what we recommend to our clients, it's very, very important that the indemnification provisions in your purchase agreement cover that period of time for the transferee prior to the closing and for the transferor after. So having solid indemnification provisions in your purchase agreement is very, very important if you know that you're going to be novating the government contracts post-closing.
So, some of the key issues here that I think are kind of best practices for anyone who's even considering a novation. Number one is definitely this advanced notification to the CO, talking to the contracting officer, getting some idea of where they're coming from, how they would view a particular transaction. it can be tricky sometimes to speak to them about how they would view things, especially if you're not entirely sure that it's going to go through or how they would take it. But to the extent you can, and as early as you would feel comfortable, speaking with them is certainly something that you should do and really think about, because it's much better to get out in front of things and know that you're working with a very difficult contracting officer than going through the expense and the process of putting all the documents together and negotiating deals and things like that, only to find out later that this particular contracting officer, or ACO, is going to really make it a tough ride. In a perfect world, make sure there's some active work in the contract, or if even there's some small order that you could put through an IDIQ vehicle, if you have a good relationship with the CO, or if it's a 8A or something like that, you could do a small sole source contract. Even something like that would be ideal to try to grease the skids and make sure that that quote-unquote asset issue that has come up that I mentioned earlier with empty vehicles doesn't occur to you. And like we said, there's some M&A, pure corporate issues to think about as well when you're dealing with what assets to transfer, some of these indemnifications. So those are definitely some of the key points that we've sort of gone over here. And so I think now, here, I'll put up this. If you have any questions, just let us know. I know we have a lot of questions, so I want to start going through some of those. And there's our contact information. We will be putting the slides up on the website, and we will also have this recorded, and it'll be on YouTube. Here you can see some of this other information. I'll leave that up while we go through some of these questions, and just let everybody know that these slides will be available. Let's see here. There's some questions about the role of the ACO and things like that, and I guess I should clarify. When I was talking about the ACO and their position, I was speaking purely to their position with regard to novations, or vis-a-vis novations, not necessarily their role generally within the government. The individual contracting officers for your contracts are still the ones who control day-to-day issues, the ones who control the money, modifications, all that stuff. So it's not like the ACO is sort of their boss. But for novation purposes, they do. That's who should be the gateway, I guess, for all the paperwork. That's really what I meant with that stuff. Let's see here. There's a question here about held off from allowing a subcontractor to assign their subcontract to a new company because they do not have the consent to subcontract to a new company. If you submit a subcontractor, if they've purchased another company, do you need to obtain consent to subcontract again since the subcontract is now owned by a different entity? And that's under FAR 52-244-2. If there is actual consent to subcontract in the contract, in your prime contract, and you are novating that prime contract to another individual, if the subcontractors are not changing, then generally speaking, the initial consent would apply, and it would sort of be ratified to the new company by way of the novation agreement. So you wouldn't have to get a new consent necessarily. But frankly, if your contracting officer wants new consents, then that falls into that kind of gray area where legally it shouldn't be required if it's the same subcontractor, just a new prime. But if the CO wants it, it's sort of a best practice to give it to them and try to make things as easy as possible on their end so that they'll grant the novation request, because it is largely in their discretion. Let's see here. Some are too specific. Yeah, someone asked about the content of the novation packages, whether or not it's dictated by the government or it's dictated by the FAR itself. And it is dictated by the FAR. It's all in FAR Part 42.12, which is 1200. So it's 1201, I think, to 1207 or something like that. So 48 CFR 42.1200 et al. That's where all the requirements are found. And some of these issues, except the things that we've talked about that are sort of best practices, aren't necessarily in there. It's more through experience, so it's just something to think about. But the main requirements are definitely in the FAR itself. Okay. Yeah, and people asked about, like I said, if you didn't hear everything, or if you came in late or couldn't get connected. Yeah, it's all going to be on the website and at those areas on YouTube and things like that. As far as novations for cooperative agreements and grants as opposed to contracts, it's pretty similar, where you can transfer, unless it's prohibited by the plain language of the contract or the actual grant, because this would apply to contracts as well. It's pretty rare, but there can be specific instances where there's a termination provision, so that if something's transferred, it'll be terminated. It is a little bit more common when you're talking about cooperative agreements and grants because of the nature of those vehicles. A lot of times the government contracted with somebody in particular, and they're looking for a specific subset of expertise or a close working relationship with them for those sorts of cooperative agreements. And so in those contexts, it's more likely than in the general contract context that there would be a provision prohibiting transfer. But if it's not prohibited, then I would get out early with the CO and communicate with them that you're thinking about these sorts of transfers and that you are going to follow the general novation procedures unless they say otherwise. And then just see what they say. Otherwise, if they say nothing, I would go forward with the general novation requirements in the FAR, in FAR Part 42. Let's see here. There's a question about certification after the novation. It says, after the novation, when the transferee has to recertify as to size, does it then have to count the transfer's number of employees or its average revenue for the last 3 years in the transferee's employee and revenue count? If you're transferring just a few assets in a contract, then when you recertify, you don't have to count the revenue going back 3 years. You just recertify essentially to the size that you had just before the novation. It would pretty much be identical because it's still just your company. If you're transferring all or substantially all the assets of a company, and so there's a number of novations, or even if it's all the assets with only one novation, then at that point you would have to count back 3 years, because if you're transferring all or substantially all of the assets, it's considered to be tantamount to a stock sale, which requires you to count the revenues of that entire company going back 3 years. So it is retroactive, so to speak. So it's something to think about, especially if you're going to be the acquiring company and you have, let's say you're relatively close to your size standard right now, and you have 15 or more you have a lot of contracts, right? You're going to have to recertify, not just, and you're buying all the assets of a company or the stock of a company. You're going to have to recertify on all the contracts you have right now, not just the ones you're acquiring. And so a lot of companies I've worked with have really balked at that, given the rule change that went into effect. I can't remember if that was a 2011 change or a 2013 change. It might have been 2013, in July 2013, I think. So when that change occurred, it was something that was really important to people to remember. And so a lot of people have said, wait a minute, maybe I don't want to do this. And they've waited till they've outgrown their size standard and then done some of these acquisitions after the fact. And even if you can't recertify as small, the contracting officer doesn't have to terminate the contract on the spot. They can keep it going for the life of the vehicle. So it's just something else to keep in mind when you're talking to the CO. You might want to let them know that you're going to do this. If you do this, you're going to have to recertify on these things. You might not be able to recertify as small, but you're ready, willing, and able to continue performing the contract, and they can keep you on for the full life of the contract plus options, even if you can't recertify as a small business. They just can't take credit for it after the recertification point, and just got to kind of get them comfortable with that. Let's see here. Another person asked about the transaction itself and can it be contingent upon the novation being approved? Absolutely. Yeah, most, if not all, of the transactions that we deal with that have novations as a component, we make it contingent upon the novation. And so if the novation does not occur or if things get hung up, there are provisions that we put in the transaction documents that essentially unwind it as if it never occurred. So it voids it all out, and the parties can either go their separate ways, or I've done it once where we did an asset sale where there was a novation involved. We got through the process, and at the GSA SBA level, we started getting all these questions, and this is why the issue came up that I noted earlier about empty vehicles. We started getting all these questions about how this is an IDIQ vehicle that's empty, and they don't consider it an asset. It was all this big fight back and forth, and eventually we decided, this is not worth the headache. We backed it all out, and we redid it as a stock sale. And as the stock sale, then all the transfers occur by operation of law. We did the stock sale, and we actually merged it up. So it was like a double transfer by operation of law, which obviated the need for any novation. So we went about it that way. But we definitely backed it all out and voided the initial transaction. So I would recommend that those things absolutely be included. I think we're coming to our time here. So, thanks everybody for attending. And like I said, you can get this slides on our website. You can find the audio, and we're going to post it on LinkedIn as well. And the audio and the video will be on YouTube, so you guys can see that. And if you need anything, just let us know. Our email addresses, I'll put that back on. Our email addresses are here if you have any questions. And any questions we didn't get to, I will answer through email to the individual parties. And if there's any follow-up, feel free to give us a call, and we're more than happy to talk things through with you. So thank you very much again, and I appreciate the attendance. Have a good day.